Morning, Ms. Lee.
Good morning. May I please the court? My name is Macy Lee for the Commonwealth. I'm here to urge the court to reverse an order by the motion judge allowing the defendant's motion to suppress because
Let me just ask you a general question.
Yes, Your Honor.
If I'm walking down the street, do the police have the right to pull me over, just beckon me over? I'm not doing anything that's a violation of the law, and take my identification from me? Let's say I give them my driver's license.
Absolutely, Your Honor. I believe that your question requires a two-part analysis. The first analysis would require this court to determine whether or not there is a show of authority when the officer is conducting a field interrogation observation. A field interrogation observation, as the court is well aware, occurs on a daily basis. It's part of a regular routine function by police officers.
Can they confiscate a license or an identification?
Before I get into that analysis, again, the analysis involves whether or not there is a show of authority. If you willingly approach the cruiser and you provide your name, then and you're in a public area, you're not confined in a room, you're not confined on a bus.
They show their license?
And float a show of a badge is not a show of authority, according to what this court held in Commonwealth versus Sanchez.
Because the idea is the person can go, they don't have to comply, they can walk away.
Absolutely.
Right?
The crucial analysis in this case is whether, based on the totality of the circumstances, whether a reasonable person would feel free to leave.
But once they have your identification, you're not free to leave, are you?
Yeah, absolutely you are, because in the circumstances where there's not a show of authority, where you are not confined
They've got
in
your
space.
ID.
But again, if I may back up, and you willingly provide your name, and there's no show of authority, and you voluntarily give your identification to a police officer, then of course you can still ask, and you don't make any attempts to terminate the encounter in any way, such as in the facts in this particular case, then you are still free to leave, and a seizure did not occur in the constitutional sense. In this particular case, there's been absolutely no finding by the motion judge that the defendant attempted to terminate the encounter at any time. In fact, the findings indicate that Officer O'Connor, who was in an unmarked vehicle and in plain clothes, approached the defendant, who was walking in a public street near a housing development.
Ms. Lee.
Yes, Your Honor.
Does the Boston Housing Police have authority to make arrests, stop people on non-Boston public housing property?
I am unaware of. I don't know the answer to that question.
How come?
I don't know if
Isn't
Officer.
that fairly important here?
Well, I know Officer O'Connor is a housing police officer, and he was patrolling the area where he should have been patrolling, which is a public housing
No,
development.
I understand that, but if they do not have authority to show, if they don't have jurisdiction to engage in the kind of conduct that they did here, whatever the ramifications are, then we view them simply as a citizen, don't we?
No, in this case, Officer O'Connor had the full authorities of a police officer. Again,
No, you have the authority of a police officer, but the question is, where can you exercise that authority?
he can exercise it where he's patrolling in the area of the housing development. And I believe here in this case, Officer O'Connor did testify that his...
No, but this is on a public street, so obviously the Boston Housing Authority, there are many different properties, and you go
Absolutely.
from one point to another. So what's the basis for saying that that an officer of the Boston Housing Police can carry out the functions of the Boston Police or the Cambridge Police or, if you have a regional housing authority?
I believe, Your Honor, that...
It's not a question of what you believe. What is the law?
Well, I think the law is that here, Officer O'Connor is a housing police officer. He's
No, that's
patrolling...
undisputed.
I understand that, Your Honor. And here, this is a public sidewalk, which is annexed to the public housing development.
I understand that.
And part of his duty in patrolling the area, he's obviously in a cruiser. He himself is on a public street, driving on a public street in his cruiser. And his authority is to patrol that area. And that would include the streets connected
His
in and
authority
around.
may be to patrol Boston public streets?
In the public housing area development, which is what occurred here.
Is there any authority for your position?
I believe that there are...
I have some interest in this because I used to be at an institution that has a police force, a licensed police force.
Right.
And it has property all over a town, and it was not permitted to engage in this kind of conduct on the public streets of that town.
But here, in order for Officer O'Connor to perform his duties in a cruiser, he himself is driving on a public street.
Yes, and
that-
when he is on Boston housing property, he can perform his functions, and when he's not, he cannot perform those functions.
But, Your Honor, I argue that part of performing his functions would be patrolling on the public streets surrounding the public housing.
I know you're arguing that. I'm asking for the source of authority for that.
I believe that
Because, for example, Boston Housing owns properties that are a mile apart,
correct.
right? And he has to travel from point A, Boston Housing property, to point B, Boston Housing property, and halfway between the two, he's half a mile from either. Can he engage in this conduct there?
I don't know the answer to that question.
Well, what is the difference between that and the public way that is immediately adjacent to it?
Here, he is at the housing development. He
No,
is
he's not at it. He's not on it.
He's not on it, but he is within the vicinity. He is actually, Officer O'Connor testified that he did not recognize Mr. Lyles because he did not recognize him from the housing development.
I
And
understand
part of his
that,
duty,
well, I mean, you're not answering the question.
I
As to
don't know.
what the difference is between a public way that is 1 inch, 1 yard, 1 mile. You either have jurisdiction or you don't have jurisdiction.
And I don't know the answer to that, but I will be happy to get back to the court.
I mean,
through-
it seems to me pretty basic.
Was that raised?
That actually was not raised. That was not challenged. The only thing that was challenged below before the motion, the suppression hearing, was that he was seized for the constitutional purposes and
How do you
the suppression.
distinguish this case, please, from the defendant's, where here the defendant's ID, his license was kept? How do you distinguish that from removing the defendant's shoes in the case of Borges?
In Borges, that case is very different from here. In Borges, that involved an investigatory stop, and this court held that requesting the defendant to remove his shoe exceeded the scope of an investigatory stop. The facts in that case involved a pedestrian approaching the police officers, telling the police officers that the defendant was seen at a nearby bar selling heroin. The police officers then went to the bar, did not see the defendant there, but saw him on the street. And by the time the police officers parked their cruiser on the street, the defendant had gone into a store. The officers then followed the defendant into the store, approached the defendant while he was in the store, asked him to come out, leave the store, to come outside and accompany them on the street. And as soon as he was on the street, one of the officers told him to remove his shoes. And although the subjective intent of a police officer is not relevant to the analysis for whether a seizure occurred, an officer did testify that the reason he asked the defendant to remove his shoes was that he knew the defendant was on parole and that he knew that he was a flight risk. And
So
that
you
was
had a seizure to begin with.
that's exactly right.
And the issue was whether removing of the shoes was beyond the scope,
That's correct.
reasonable scope of the purpose of the seizure.
That's correct. In fact, I would argue that this case is very similar to the case of Commonwealth versus Evans. In that case, although it did involve the function of the community caretaking function executed by a police officer, here we have a field interrogation observation, a very similar routine function that is executed on a daily basis on police officers. In Evans, a car was parked over on a breakdown lane. The state trooper pulled
But
up behind him.
This doesn't fall into that category.
It
at
does
least
not.
as I read
Absolutely
the
not.
policy. This is completely contrary to the policy.
Absolutely not. But in that case, this court held that taking the license and registration of the driver did not constitute a seizure.
Taking a license and the registration for the driver is a different line of cases, isn't it?
Yes, it is. Absolutely.
Let me just ask you this. I'm
Yes,
just
Your Honor.
looking at the officer's. I'm just looking at the officer's testimony.
Yes.
This is just a basic encounter to identify somebody. We didn't have any reasonable suspicion or probable cause that any crime was being committed at the time. We just identify him.
That's correct.
Now, it is obviously perfectly permissible for for a police officer, providing that they have jurisdiction, to go up to somebody and to say, "Can I speak to you?" It may even be permissible to say, "What is your name?"
That's correct, Your Honor.
You're saying it's perfectly permissible for them to say, "Could I see some identification?"
As long as...
No, wait a minute. The answer
Yes,
to
Your Honor.
that is?
I'm sorry?
And the answer to that is?
The answer is yes.
Okay,
Again,
so now, I have my driver's license on me. That's the only identification. And to follow up on Justice Island, I hand over my driver's license, and you say, "That's okay, because I'm then free to leave."
again, yes.
Leaving my driver's license with the police officer?
Yes. Again, we must view the totality of the circumstances. If there's absolutely no show of physical force, if the police officers did not frisk you, if he did not block your path or
but I
free
But
your
what am I supposed to do about driving my car after that event?
Well-
If I chose to leave because I'm free to go, but the police have my driver's license?
You can then request to terminate the encounter by requesting the returning of identification. And if the police officer refuses, then I believe the analysis goes down a different path once that occurs.
Because then it's a seizure.
That could possibly very well be a seizure at that point.
So what the person's supposed to do, the rule would be, you've got to ask, may I have my license?
That's correct. Whether an
Or
object...
refuse to give the license.
Absolutely. And
But then if you refuse to give the license, does that then give the officer adds to the escalating situation, so the officer would
It does.
would be wary of this person because he refused to produce his license?
Absolutely. In the case of Commonwealth versus Barrows, this court held that the initial request, hey, can I speak to you, was not a seizure. It was a proper field interrogation observation. However, it escalated to when the defendant broke eye contact, walked away from the police officer, and the police officer continued to pursue him and got out of the car, and that's when a seizure was effected.
But then is it a catch-22 situation? Because if the individual can give over his license, then he can't leave because in our society, you really can't go very far without your license.
Yeah, that's correct.
And if he refuses to give it over, which he's free to do, that just gives the officer grounds to say, well, you may be armed and dangerous. There may be something, suspicious here.
But then again, if there is something suspicious, then the analysis changes, obviously, because
But I'm asking you how, but it doesn't change to the benefit of the individual.
it doesn't, without just the circumstances that you just provided me. If the police officer refuses to honor your request to leave, then again the analysis changes, because is there a stop at that point? Are you free to go? Is there a show of physical force?
If the officer doesn't honor your request to leave, then of course you're not free to go.
Absolutely, and then again, the officer's tone would then change to one that's aggressive, one that would command compliance, one that would give a reasonable person the feeling that he or she is not free to leave. And in this case, none of that occurred. In fact,
Can I ask you some questions
Absolutely, Your Honor.
about this case?
Yes.
First of all, there were two officers, not one. They
That's
both
correct.
got out of the car and they confronted the defendant.
That's correct.
They asked for his identification. Now, the trial judge here finds that the defendant did not voluntarily provide his identification to the officers. What do we do with that? Is that a finding of fact, a conclusion of law? What is that?
I believe that's a conclusion of law that's unsupported by any of the finding of facts or by the record. That's a legal determination made by the judge. The findings that were made by the motion judge included that, and I quote directly, the defendant was not known to either officer and he was alone at the time. That's a finding. Based only on his observation of the defendant walking along a public sidewalk, Officer O'Connor and his partner got out of the unmarked vehicle in which they were riding, approached the defendant, and asked him for his identification. The defendant provided his identification to the officers. That's all the finding of facts that were provided to us by the motion judge. Furthermore, in the defendant's affidavit in support of his motion to suppress, there has been no allegations whatsoever that he felt that he was not free to leave. He simply says that he did not consent to the questioning, but he did not say that he gave his identification to Officer O'Connor involuntarily. So based on simply just on these findings, the legal conclusion I
Well,
brought.
the next finding under the one I just referenced was the officers restrained the defendant to the point where he was not free to leave.
Right, and that's a finding that's not supported by the record, because if you look at the testimony by Officer O'Connor, he said there was no order, we were just talking, we didn't order him to do anything. This was an encounter, he was free to leave, I didn't stop him. This is all on page 8 and 9 of the transcript of the motion hearing. He further testified that this was just a basic encounter to identify someone. We didn't have any reasonable suspicions or probable cause that any crime was being
Let
committed.
me ask you this, how long can the police hold on to the identification?
I don't know. I know in the case of Commonwealth versus Thing Van Co., which did not involve identification, but involved the approach of various Asian males in Boston's Chinatown during an Asian gang task force investigation. That case involved a detective approaching males in a public area, asking them for their name, their date of birth, their address, and also recording their physical descriptions, and then continued talking to them for about 5 minutes while they ran a warrant check on each individual, and then also taking a Polaroid picture of the individuals for their files. And this court held that that was not a seizure in the constitutional sense. So 5 minutes occurred in that case. In Sanchez, Commonwealth versus Sanchez, that was an airport case where the defendant voluntarily gave his airline ticket and his license to narcotic detectives, and then he then suggested to go into the men's room to do a further check, and that's when he fled. I don't know the time in that, but it seems to be about 5 minutes perhaps. But I know in Thin Van Cove, the court did hold that the encounter lasted at least 5 minutes.
Can I ask you one further
Yes, Your
question
Honor, of
about the
course.
transcript? Because this, of course, is a common frustration.
Yes.
You know, the officer says, we observed him in the area of the community housing development. We had several complaints about drug activity, inaudible. ADA, inaudible. What was the result of that? We ran his name through BHA operations. Have you tried to sort of reconstruct those critical inaudible?
I apologize for those inaudibles. I have listened
Well,
to
not your fault, but I
no,
mean-
I've listened to the tape itself numerous times and gone through the transcript numerous times. I've had other people with a clean, fresh air listen to it, and no, I did not make any attempts to reconstruct the record, but that's something I will note for the future and attempt to do for this court.
Doesn't your position hedge on our finding that a reasonable person, when asked by the police for an ID, would believe that he was free to walk away?
Absolutely, Honor. And again, viewing that question in the totality of circumstances, considering physical force, whether there's any intimidation, the tone of Officer O'Connor, and that he was in a public area, and whether or not he provided his identification, which we don't know what it was, whether it was a library card or a driver's license or even a school hall pass at this point, but whether or not that was voluntarily given to Officer O'Connor.
And that comes in the context of having many states which require somebody to give their ID, doesn't it?
In the case Texas, Brown versus Texas, which the defendant heavily relies on, that actually involved a state statute in Texas that made it a crime for someone who refuses to answer to the orders of a police officer in providing identification. And the Supreme Court held that statute was unconstitutional under the Fourth
Ms. Lee,
Amendment.
do you see any difference between somebody being asked their name and being asked to produce identification at that point, which may be required in some states, is not required here, and being asked, and the police officer then keeping the license and running a check to see if there are any outstanding warrants?
Would I think that that's a difference? No, again, I think that is consistent with the functions of the field interrogation observation, which is to ascertain the identification of a
Well,
person.
you've got the identification. I mean, he didn't say so, but you know the identity of the person either because you ask the person's name and they hand over the license. That's not exactly what happened here. They then proceeded to use that to run a warrant check.
That's correct, Your Honor. That did occur, but I
Do
don't.
you know what the leading treatises say about that? Do they draw a distinction?
I don't. I do not. The one case that I can think of is Commonwealth versus Thomas.
No, I just wanted to sort of around the country, as we
The
are now
country.
looking around the country. Do the
I'm-
leading treatises make a distinction at that point?
I'm unfamiliar with any of the cases that I've read that concern obtaining the identifications for the purposes of a warrant check. The cases that
That's what happened here, correct?
that did happen here. The cases that I have in mind are Florida versus Royer, the Supreme Court cases where they involve the airline ticket or a bus ticket and a license, but for the purposes of searching luggage, but not for ascertaining whether there was an outstanding warrant.
Thank you, Ms. Lee.
Thank you, Your Honor.
Ms. Murray?
Good morning, Chief Justice Marshall, good morning, members of the court. Crystal Murray on behalf of the appellee, Oscar Lyles. With me is attorney Mary Norton, who was the trial attorney. Your Honor, Chief Justice Marshall, perhaps I could lend some clarity to the questions you asked
That would
about
be most helpful.
the authority of the police officers, with the caveat that my Boston police regulations on quote-unquote special police officers is not perhaps up to date. Let me tell the court what I have read from those regulations.
You can use your time doing that if you are waiving that argument. I saw it only because it was part of the defense counsel's examination. If it's not an issue in this case, that's
Well,
fine.
it wasn't raised below, Judge, but you're absolutely correct. Parker Street happens to border the project, but it's not an integral part of the project. in special police officers, the authority of special police officers as bestowed by the Boston Police Department requires licensing, and on the license itself determines the jurisdiction of the officer, just where physically that person can exercise limited powers.
Was that all before the motion, Judge?
No, it wasn't, Your Honor, but it was because it
Was
came
there
up this
testimony
morning.
that Parker Street borders the project?
Yes?
I believe that, yes.
There was a line of inquiry.
Yeah, about it being a public sidewalk. It definitely is. It's a major street in Roxbury.
Can I cut to the chase here a little bit?
Sure.
On what the findings of the judge that he ultimately made on remand from the appeals court? I mean, it strikes me that the judge is saying that the mere request for the identification in these circumstances was a seizure. Is that your position?
I can see where you could interpret the judge's findings that way, but he also says that that request was or the handing over was involuntary. And he does use the word ask, I admit that. But nowhere in those transcripts is there a word ask or request or, if you don't mind, anything like that.
Presumably that's in the inaudible parts.
Well, how do you reconcile that with the statement that's not inaudible, where defense counsel on cross-examination says to the officer, you ran a check of the Board of Probation and he complied with your order. He gave you his ID, yes. Now, there's the word order.
But he had before that said it wasn't an order. I mean, the officer.
The officer. Let me point out, I think there's two reasons why we must consider that the police officers taking control of the license as a seizure. One is the more obvious one that's come up, and that is that the person in today's society is crippled without a license. I wouldn't be standing here this morning if I didn't have ID to get into this very courthouse. But I think another point that we have to make here is the purpose in this case is the purpose of taking the ID in this case was to run a warrant check. Now, that in itself would lead a reasonable person to believe that they couldn't walk away while the police are determining if there is an order to arrest them out there. I think that's very important. And so when the police officer says he was free to leave, I say that's absolutely incredible. What police officer worth his or her badge would let a person walk away while they were on the phone to the boss of the police computer trying to figure out if there was an outstanding warrant?
You could say, your argument sort of breaks into two parts. You would
Right.
say that asking, quote, asking, or if the judge says it wasn't really an ask, there's an issue about getting the identification. But even if one were to say that that was requested and given, the scope of permission certainly didn't go to
Right,
looking,
exactly.
doing the warrant check.
Right, exactly, Your Honor.
So you don't dispute that they had the authority to at least engage with the defendant?
Thank you, Your Honor, for bringing that up, because I do think the Commonwealth, at least in its written submissions, has made that distinction a bit murky. We never have, the defense has never challenged the fact that the police officers, when they got out of their cruiser and said something to, can we talk to you, what's your name? We have never claimed that that right there was the seizure.
So up to that point, it's okay?
Up to that point, the case, this court has made that law that it's okay.
Not just this court.
No, not just this court. That's not, however, to say that there isn't a show of authority, maybe not a sufficient show of authority to effect a seizure, but there is a show of authority when two police officers get out of a cruiser and get in your path and they have ID and they're armed. That certainly is a show of authority. So this is why I think we can reconstruct the trial judge's thinking. That's how it begins. Then, and incidentally, we can't overlook the fact that it's the government's burden here to show that there was not a seizure, that there was consent, and that the consent, the scope of the consent was appropriate.
Is there a way that the police could request identification without it being a seizure?
I would, without it being a seizure? That's a difficult question, because I don't know that I know enough facts.
Well, but,
What
I
I
mean-
started to say before was that at this point, after you have this interchange between the police, the armed police officers, and Mr. Lyles, and now they want his hard copy, if you would, identification. I can believe that this is what I think the judge was reasoning. There has been no evidence whatsoever, and again, the burden's on the Commonwealth, no evidence that he was ever told why he was being interrogated or questioned. There was no evidence that he was told he could leave. There was no evidence that he was told he did not have to answer the questions. And instead, and I think this is an important point, the very nature of the request, command, whatever, is an ominous demonstration of state power.
How did the officers communicate with the record keeper? Did they do it by handheld radio or car radio?
Handheld.
So that they, I suppose, theoretically could have, read the information off the license, radioed it in, and given it back to the defendant, but they didn't do that.
It's not the case here.
So if a 20-year-old is stopped on the street, the police officer can walk up to him and say, "What's your name, son?" That's okay.
That's your law.
Can say, he says the name and it says John Smith. He said, "Can I see some ID just to verify that?" Is that okay?
On those sparse facts the court has given me, on those limited facts, I might have to say yes.
Okay,
but
so
again,
it's-
I'm
so it's not-
concerned about the nature
I understand,
of the
but
request.
it's not. You're not saying it's per se that
I
per
am
se
not saying
transforms it. But I
as
gather
far
you.
as the court went, I am not saying that's per se.
But I gather you
saying
are saying that if this John Smith hands some ID, when the officer takes it,
no question about it.
once
It's a seizure.
so it's the taking of the ID, not the showing of the ID, which you
But
claim
it
to
could be it could be also the showing of the ID based on the circumstances.
Let me tell you what the United States Supreme Court has said about that. We may not follow them, but this is what they've said about just showing the identification. A seizure does not occur when police ask to examine the individual's identification, so long as the officers do not convey a message that compliance with their requests is required. So I don't, at least according to the United States Supreme Court, it's not a bright line rule.
No,
It
Your Honor, but I
depends.
think that you have to, if you, an interesting case, maybe the only case that comes close here, is Commonwealth versus Murphy. And in that case, the court seems to suggest that asking or requesting whatever, an identification, not just the name, but an identification, that in itself is a request that commands compliance, and therefore could be considered a seizure.
You said that's Commonwealth versus Murphy?
That's Commonwealth
That's
versus
Judge
Cash
Brasso-
Money
that's
Murphy.
Judge
I don't have the
Brasso's-
site, but it's certainly in my brief.
63 Mass Appeals 411,
Well,
Judge Brasso's.
the demand, the request came during the pat frisk. Clearly, if there's a pat frisk,
But if,
that's a
Your
little
Honor,
more than just a request for identification.
But if we
You mean in
read
Murphy?
the opinion, you'll find out that
In
the
Murphy.
court, at least twice that I can remember, and possibly 3 times, uses the disjunctive. The quote is, the directive to produce an ID as part of an FIO was not a request for voluntary cooperation, but a show of authority expected to command compliance. And I know one of the quotes I have in mind is the court goes on to say there was no factual predicate to support the pat frisk or the warrant check.
So, but the
Well, no, the quote is, the court says, the demand that Brown produce identification made as Jenkins conducted a pat frisk was not a request for voluntary cooperation, but a show of authority. So they are linked here, at least that's the facts.
the other point, I think, is demand versus request.
Right,
That goes just to the initial.
right. And again, our position is that here it was ordered. And obviously, the motions judge agreed.
But I take it you're also saying that even if it's not, even if it weren't ordered, the retention of the license, the control over the license.
Absolutely. And again, I'm saying that in terms of a request under very benign circumstances, I still think the nature of the request, while not conclusory, is a factor in the calculus. The fact that the police officers are asking for proof. Even Justice Cass in Alvarez says very clearly that that's of great concern. There's a big distinction between asking a person for his or her name and asking for documentation of the identity. I don't remember his exact words, but basically it was a badge of a totalitarian society. And I think that as a society, that's how we view it.
Remind me, Alvarez, the question was asking the passenger in a stopped vehicle?
Yes, and that's an interesting line of cases that culminate in Alvarez, because there the court has held that unless there's reasonable suspicion that the passengers are engaged in some sort of criminal wrongdoing, that once in a traffic stop, the driver produces a license and registration, that the interrogation of passengers may not take place.
Of course, that's very inconsistent with recent U.S. Supreme Court jurisprudence.
Right. But that's the case law here. And so ironically, and I note this in my brief, it seems like if Oscar Lyles had been a passenger in a car on Parker Street that was pulled over for a driving infraction, and the driver had complied and there was no evidence, like here, of any wrongdoing, then he absolutely could not have been asked for any ID.
Yeah, it's interesting. I mean, the Supreme Court has now said that passengers are seized in the same sense that drivers are seized once it's a traffic stop. Everybody in the car is seized.
Well, I think that our courts have acknowledged a temporary seizure.
Yeah, and that in the context of a justifiable seizure, which that would be, surely the police can ask, this is the U.S. Supreme Court recent jurisprudence, can ask questions of the passengers. They can even conduct pat frisks of the passengers if they have a basis to think they might be dangerous. Can they ask them for IDs? I'm talking U.S. Supreme Court Fourth Amendment jurisprudence.
I don't know.
They can certainly ask the driver for an ID.
Yes. And
all the other passengers are seized. And I think the U.S. Supreme Court has said if you're seized based on reasonable suspicion, then asking for IDs is
Well, that may be, if there is reasonable suspicion.
Well,
but
I mean,
don't know.
the problem with the motor vehicle line of cases is that you stop a motor vehicle because it's speeding. The passenger isn't suspected of speeding, but in fact they are seized for constitutional purposes.
And Alvarez was very clear on the fact that there was no reasonable suspicion of the passenger's involvement in criminal wrongdoing. So I just want to make one more point. The defense is not asking this court to carve out new law. This case can be decided on the existing law of seizure, that when the police took control of that license in this case, that Oscar Lyles was not free, nor would any reasonable person have believed they were free to turn around and walk away. And in that instance, to uphold the trial court's ruling.
Thank you, Ms. Murray.
SJC-10267, Commonwealth versus Johnson.